What's up, everybody? Welcome back in. We're getting started on this Alec Baldwin trial. They're picking a jury right now. But before we even get to jury selection, yesterday there was a ton of pretrial motions that were argued by the defense lawyers, by the prosecutors on the case, a lot of decisions made on the judge, and we get to learn about everybody's personality in this hearing. Things got a little heated. They let Miss Morrissey, the prosecutor that was on the Hannah Gutierrez retrial, know that she is not going to get away with the same antics that she did in that trial. And the judge made quite a few calls pretty quickly and was prepared and ready to make them. So we get an idea of how she's going to handle this trial. And the defense attorneys pretty much controlled the courtroom, which the judge, I think, pushed back on a little bit. We're going to get to all that and more, talk about what was decided, answer your questions. Make sure you guys hit the like button and subscribe to our page. Make sure you hit the reminder bell so that you don't miss any Alec Baldwin videos. We're going to be doing daily recaps for the most part throughout this trial, as long as you guys are interested. Let's get into it. All right. So what's happening here is before every trial, it doesn't always happen the day before. Sometimes it happens on the first day of trial, which really sucks because it makes it hard to prepare. But at some point before trial, and we've seen when we've looked at scheduling orders, the last time to file motions, the last time to argue motions, stuff still happens. It's not unusual that all the way up until the day of trial or the day before, the judge will schedule one day to handle all outstanding pretrial motions. And that's what this is. There's a lot of motions in limine, motions to exclude certain things, to include certain things, courtroom procedure, jury selection, jury questions, all to be handled and figured out the day before trial so that all the lawyers can know what to expect going into trial, that it's not looking like a circus as the trial is going on for the most part, as much as we can control. We always have to be adaptable and ready to deal with whatever it is comes our way as lawyers. But that's what this motion was. So we're going to go through, we're going to talk about a lot of it. We're not going to hit every single thing. It was 7 hours. We're going to talk about a lot of it. We're going to play some clips of some of the interesting portions of this hearing to talk about what decisions were made prior to the trial starting today, where they are picking a jury, and they talk a lot about what jury selection is going to look like, and we'll discuss that as well. So the first one was a motion to exclude two witnesses. One, the state was able to depose. One, the state was not able to depose, but the defense added them in response to the producer theory. Okay. And a big portion of this hearing was whether or not the state was going to be able to argue the producer theory. Were they going to be able to argue that the buck stops with Alec Baldwin? Everything that happens, safety and otherwise, all comes down to him. He was in control. He should know. He should stop it. Okay. We're going to talk about the judge's decision on that later, but the judge denied the state's request to exclude these two witnesses, said they've already cured the problem on one because they've already taken their deposition. The other one, they said they can't take their deposition. I think one of them was like an investigator that said the state did a horrible job. The state said, oh, it was sour grapes because we fired him. Well, that person, the defense, is absolutely allowed to call. So that makes sense there. Then the defense filed a motion. Was it the defense? No, I'm sorry. The state filed a motion to exclude the civil lawsuits, and the judge denied it. The state argued that they were different causes of action. They're wrong on their argument. The defense was right. Judge made the right call. I really liked the judge throughout this entire hearing. I thought she ran a tight ship, which is interesting based on how the first trial started. And that's a perfect transition into the defense does not want this trial to look like or be run, especially with objections and making comments that the jury can hear. If you go back and listen to our early videos on the Hannah Gutierrez retrial, I complained about this nonstop. It was so frustrating. It was annoying. It was borderline misconduct that the prosecutor was just saying stuff that the jury could hear. I thought she did a good job prosecuting the case. I thought she was tough. I thought she wanted to literally hammer Hannah Gutierrez Reed as hard as she could. But there were certain ways that just is not how it's supposed to look in a trial in a courtroom. And we're going to listen to this part of the argument because I find it to be very interesting myself. We'll try 1.5. And if you want to slow it down, hit this gearbox. You can slow it down. If we need to slow it down, we will.
And yes, Your Honor, I think this is a good place to start today because this is sort of my main issue throughout the day and what I'm going to ask to address at various points. And that's why I'm going to keep my remarks so brief on all my motions, because hopefully the court will give me the courtesy of a few more minutes when I need at the end. But essentially, the court has the papers. Their response that the state is allowed to burden shift in certain places. That's their sort of strongest response. Misses the mark. I mean, even in the case they cite, right, what the prosecutor does, it's one remark in summation where the prosecutor says, I, of course, have the burden of proof. it never leaves this table. This is a very serious proceeding, and I have the burden of proof. Just so you know, though, you can consider, and then they make one remark. That's the context of any case that goes against these basic propositions that are also the same in every single state in this country. So the reason that I had to make this motion is because in reviewing some of the trial, and I haven't been able to get through every bit of it that I want to on this subject, but
it's kind of wild that he still hasn't watched the whole trial, and it's just so similar. So many similarities are going to be in this trial, but he is watching. He is watching, and he found this to be a major issue, and I couldn't agree more.
It's constant issues with controlling the prosecution from doing things that are just straight and proper. And so I don't know what to do in that circumstance. I've never made a motion like this before, but it's objection. This witness doesn't know that. Objection. They don't know how to identify the picture. We have plenty of other witnesses. Sometimes it was no objection at all. Sometimes the prosecutor just called out from the prosecution table and started saying, I would request the witness read the entire transcript. He can't answer that. And then there's the questions, and we'll get to this in another mill, which is constantly, every single witness. They'd ask a question, what happened next? And where was Miss Hutchins during that? Where was Miss Hutchins? Oh, she was in the helicopter. And then they would go on. And they would ask another question about the chronology. And they said, well, where's Miss Hutchins? She's in the helicopter. And so, this is, it's misconduct. You can't do that. You can't do that as a prosecutor. You're not allowed to do that as a prosecutor. It's very serious to do that as a prosecutor. And so eventually the court at some point stopped Ms. Morrissey from doing the coaching, speaking objections. And then Ms. Morrissey began.
It's absolutely true. We've seen it in other trials. And this is funny. I mean, this is the argument I've made in so many videos boiled down to a brief that he's basically arguing to the court. And he's even saying, like, I don't even really know what I'm doing, Judge. I'm just asking you to make sure they follow the rules we all know they have to follow, that they very clearly did not follow in the first trial. And he said he like almost apologizes for this motion multiple times.
Every time her name was mentioned in a question, she began to stand out and say, well, I'm being talked about in this question. And she began interrupting the proceedings. So I didn't know how to address this. I don't know how to address this, even as I stand before Your Honor. But my request would be objection, relevance, objection, hearsay, and nothing else. And in the very rare circumstance when an issue rises to the level of extreme importance or constitutional imprint, a lawyer can approach. If there's something very complicated, a lawyer can approach. But otherwise, none of those tactics and devices should be used at this trial.
I completely agree with him as well. And you've heard me say, I personally think this is the best way to do it. One word, it tells what the objection is. The judge can rule. The other side can say if there's an exception or something like that. If you really have to argue, fine. Then we'll go up to sidebar. And this is how most trials that I've done, even in federal court, have been. Federal court is just a little more strict, and they really don't let you do that type of arguing, and they'll shut that crap down quick.
We've come a long way to get here. The court has been very patient. All that we want is a fair trial. And for the rest of this, I would rely on my papers. Thank you.
Response.
Thank you. Your Honor, I think we can agree on one thing.
By the way, this is the new prosecutor. The guy is gone that was here before, and she argues most of these motions, which I thought was very interesting as the newer prosecutor. I thought she did a good job. I thought all the lawyers that argued the parts, Ms. Morrissey just has a certain style to her that I know some people are going to find annoying, but they all did a really good job. And I know Nina made a comment. I recognize that one of Alex's male lawyers argued dozens of motions without any notes. I think he has hired really good lawyers. Your opinion? So yes, I definitely think he's hired really good lawyers. You can see it's the bald lawyer in the background. He is reviewing notes and reviewing arguments before he gets up there to discuss. So he is still reviewing stuff. And you'll notice he has a couple crutch things that he says. That's black letter law. That's Hornbook law. This is standard stuff, Judge. He says that a lot throughout the hearing. So it's kind of the crutch that I think he falls back on when he doesn't have notes. I think all these lawyers were exceptional, including him. I thought he did a great job. I thought he made great arguments. I thought the defense won way more of these arguments than the state did. But I thought that overall, it seemed to be a very good high-level battle back and forth between the state and the defense. That was my perception and takeaway from this pretrial hearing.
Absolutely, without a doubt, and that's beyond dispute. The state has the burden, and the state cannot shift that burden to the defendant. Absolutely agree. However, there are those limited circumstances where the state is given latitude with regard to countering defendant's arguments. For example, the defendant comes in and, as the court has heard, presents argument that somehow somebody modified this firearm. Where is that evidence? The state should be allowed, and it has been allowed, and in fact, in State versus Aguayo, which is cited in the motion, 1992, New Mexico Court of Appeals 124, the courts have allowed the prosecution to argue that the defense didn't present witnesses to support their defense theory, but the state has the burden. There's no question about that. So we would ask that the court give the state some latitude with regard to responding to defendant's arguments. And I can guarantee you, the state will not, under any circumstances, shift the burden to the defendant, because that's improper and it will not happen. With regard to—
So she's right. You can't burden shift, which the defense wants to make sure they don't. A lot of this is in an abundance of caution that the defense is making these arguments. The defense is trying to set the stage, set the boundaries, set the rules, which is what I love doing before trial, because you take that stuff out and that stressor out. If we all know we're going to play by the same rules, then you have a court order that says you have to. So if they start doing something that, we all agreed was not going to happen, you show them the court order. But she's also right that they've got to be able to respond to the defense's argument. If the defense says something is true, that's not true, they can say, nobody proved to you this is true. They're just throwing that up against the wall. That's not burden shifting.
For opinion or for witnesses. I agree it is improper to vouch for a witness's credibility, but there are circumstances, Your Honor, where the state is permitted to comment on the veracity of a witness as long as it's based on evidence. If the prosecution says, it's my opinion that this witness was truthful, absolutely improper, absolutely agree. But if it's based on evidence that a witness testified to X and there's corroborating evidence of X, the state is allowed and should be allowed to argue to the jury that this witness has testified truthfully based on the evidence.
I agree. I don't know if you have to say the word like truthfully, but you can obviously say it's credible. And this is how you judge credibility. And you can use the jury instruction that talks about credibility of a witness and how this witness fits into that. Absolutely.
And finally, part of this, during closing argument, Your Honor. Yes, no, not during trial. With regard to coaching witnesses, Your Honor, which is the last part of this motion, I agree as well. A prosecutor must not coach a witness, particularly must not coach a witness to testify falsely or to phrase the witness's testimony. However, it is absolutely proper for the prosecution to meet with witnesses, to prepare to testify. The defense has taken the position, I believe, that any sort of preparation with witnesses is improper. I would ask that the court not allow the defense to try to imply to the jury that meeting with witnesses prior to their testimony is improper. Coaching, absolutely. That the prosecution to tell a witness what to say, absolutely agree. But to meet, to prepare for their testimony is completely proper. And we'd ask that the court not allow the defense to comment on that as being improper. Thank you.
Anything else?
No, Your Honor.
All right. Well, I have to say, I don't like these kind of motions because I'm not going to be bound by it during trial where someone shows me an order and says, this is what I said.
Which is exactly what I like to do, right? I just like to know the rules. I'll play by the rules. I like to, use the rules in the best way for me and for my clients and to win within them, not to do anything unethical or wrong. But I like to force people to stay in the lane that they're supposed to stay in, because then you have the most control over projecting what's going to happen. Some judges obviously hate this. I don't know why she would hate putting them in the box of no speaking objections or, dealing with things a certain way. But we're going to hear how she says this is going to be handled. And she's not going to get bossed around by the defense or the prosecutors in this case, which I appreciate.
I was going to tell you, but I'll tell you now, based upon the ruling, every time you want to say something that is not a question to your witness, you're going to come up to the bench. So you do not get to say objection, blah, 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 and then wait for me to say to come up. You're going to come up.
I think that is so annoying. Okay. I know people, and again, I like the judge, but that is so annoying. Every objection that has an argument, you got to come up to the bench. It wastes so much time. It looks so weird in front of a jury. I hate that. I don't hate it as much as the speaking objections where you're coaching witnesses and saying things that are improper to the jury. I hate that more, but I do hate this. I do hate this. This guy hates it too. What is the problem with just saying hearsay? And if there's anything more, then fine, but oof, brutal.
And this happened in the Hannah Gutierrez trial. So
Yeah, just point of clarification. I don't have any intention of approaching during the trial other than the rarest circumstances.
no. You have to come up to the bench and put on the record your objection. You don't get to do it from there.
Okay, I have to internalize this.
He's like, come again every time I say objection.
I never had a trial conducted that way.
From there.
Okay, I have to internalize this. I never had a trial conducted that way. So I would ask to potentially address this issue. I mean, I don't think the defense or anything that I've done would necessitate changing the rules. At least I would ask them.
This is the court can do what they want with respect to objections, and this is what I'm going to rule.
And this is kind of proof to me that he was telling the truth. He didn't watch that trial. Not that I'd ever say he was lying about it, but because that's what they turned into doing in the trial. And it was miserable. It was annoying. I thought it stifled some objections. with Bowles. Like he didn't want to object and approach again, which is horrible and not how it's supposed to be done. I don't think the same is going to happen in this trial with these lawyers, but very interesting.
Cool. So I'm trying to, the sides have been contentious with one another. I think that you all may not intend to, but you might want to try to get the jury to see what's wrong with that question and or make some argument to try to influence the jury. And if you're going to object, it's going to be up here, and you're going to put on the record what the objection is, and I'll make a ruling up here.
May I just approach for just a second? So I'm glad I saved my.
He's like, let me approach right now, Judge. I agree with you. It could absolutely discourage objections, and 8 days with those kind of objections seems tough to me, but maybe.
I didn't want to address this issue, Your Honor. But I would ask and urge the court, because I think that this system could disrupt the ability to cross-examine and it disrupt the defense. It is not, as I think the court will acknowledge, it is true the court has great discretion. I think that deciding that before the trial even begins is an extreme use of discretion, just genuinely. I know that issue happened at the prior trial. I'm asking and urging the court to give an opportunity, at least to the defense, to just simply say, and I think my suggestion works, right? It's just objection, relevance. There's no other words coming out of my mouth ever during objections at a trial in front of the jury, and to allow us to have an opportunity to have what I would call a normal procedure.
He's completely right, in my opinion. So do they not have set rules all courts follow? Not, there is some, yes, but not all. And a lot of it's up to the judge's discretion. And I agree with Mo here. Kind of feels like a punishment for the last trial. And it kind of feels like it's almost like when my kids both get in trouble, sometimes I just punish both of them. Both of you guys are acting up. You both get a punishment. It's like Morrissey acted up, so you're punished too. Nobody can have any objections there. I don't love it. I don't love it. I don't even like it. But we'll see. Joanne said, have you seen the supplemental filing from Steele? I haven't seen it. I heard it exists. If you guys have it, send it to me on Twitter or Instagram, and I will get it to my dad, and we'll break it down at some point this week. Azam said, I'm digging your new thumbnails. Well done, lawyer, team. You really look like a real lawyer on it, Peter. I'm mid on it. I don't love the pictures of me personally. We're having internal discussions right now, so we'll see what ends up happening. We're going to take more pictures that hopefully aren't quite as corny, in my opinion. But regardless, he's right, in my opinion. I like doing it that way. It's simple. It makes sense. That's how I think the standard is across the board. It doesn't mean judges can't allow different things. And he said, you do have discretion. I just think it's a big time use of your discretion to force us to do that.
Because if every time there's any progress going on with a witness, they're standing up and they're making everybody come to the bench, they're disrupting the ability to cross-examine. They're disrupting the ability to put on our case. So what I would urge the court and ask the court to please do is to allow us, at least, if after the first witness, even the court wants to revert to what they did later on in the Hannah Gutierrez retrial. But I can tell the court I've tried many, many cases. I've never had that issue before. I've never had that issue with one witness in one case. So I'm asking the court to at least give the parties a chance to do it. I also am very concerned about the time, schedule, and everything else. There are lots of objections that are just objection relevance. The court will rule. If the court needs to hear more, we come up. And I'm urging, almost begging the court to at least let us start that way. And then the court can, like this, and not hear from me further on this issue. Thank you.
I'm not going to change my mind. I can see what I want to do is I want to start with you all getting the lay of the land. And I'm going to be in control of the courtroom. So this is what I'm going to do. I'm sorry that you haven't experienced this, because it can happen, and it does happen. So that's what I'm going to do. If you all seem to be doing well and you get it, and I'm hearing relevance, I agree, then we can perhaps relax the rule. But that's how it's going to start off. Okay?
So she did leave the door open to perhaps relaxing that order. But this was the most interesting back and forth to me of the entire pretrial hearing, because they watched, they saw what the prosecutor tried to do. They want to limit that. The judge also seems to want to limit that, maybe even a little too much. I think that's it for this part.
All right. So,
yeah, that's it for this part. Okay. Defense wants to exclude other bad acts like him yelling and handling the gun on set. Judge grants it in part, denies in part, says only stuff that's really points out to the crimes committed, not anything else just to make him look bad. State wants to exclude prior prosecution team investigator, like I talked about before. Judge allowed it. They want to exclude Baldwin, saying the state wants to exclude Baldwin being remorseful, and what these defense attorneys did in their experience as prosecutors in a prior life. Like some defense attorneys want to say, the defense basically says, we're not going to do that. That's fine. No sympathy will be garnered. The defense, again, argues against the producer theory. They say that the experts are not experts on producer stuff. and that it's just way too broad. The judge then pushes back and says that this producer theory is different than what the state argued in the grand jury proceedings and other arguments. And as a producer, he didn't hold, point, and fire the weapon. And the state basically keeps arguing, and the judge is like, you're trying to have it both ways. And at the end of the day, the producer, actually, let's wait. We're going to play the part where she talks about her producer theory. So that when the defense got up and argued again, they followed kind of where the judge was going and saying that, again, he's more, it's the actor of what he's being charged with, not the producer. They shouldn't be able to have two cracks at it. They shouldn't be able to have it both ways. And let's watch kind of the end of this discussion, what experts she is going to allow, what experts she's not going to allow, and what arguments she's going to allow. And before we listen, you guys tell me, do you think that the state should be able to use the producer theory? Do you think that the state should be able to argue that Baldwin was in charge of all safety aspects because he was the boss man, he was the producer? So if Hannah Gutierrez was negligent and guilty, he should be guilty because of her action, in addition to his own action handling the firearm. So what do you think? Let me know in the comments if you guys think, if you've watched, that's fine. What do you think it should be? Regardless of what it ends up being, do you think they should be able to argue this producer theory that he's in control of the overall safety?
He's not qualified to give opinions on these issues.
Thank you. The court makes the following ruling. The court will accept Mr. Kent Jorgensen to be able to testify before the jury as to what the SAG guidelines say, but he has no qualifications to opine on what a producer does. He doesn't know how a producer implements those guidelines. So he can say these are the guidelines, but he needs to be a producer to say this. As a producer, this is how I thought. This is how I meet these requirements. The other thing noteworthy about Mr. Jorgensen is that based upon his pretrial interview, which is what would have been the time to let the state know, the defendant know what he was going to testify about, he was all over the place. And basically, he was like, well, I relied on Ross. I didn't talk to anybody. So yes, he will have hypotheticals about, and he may maybe sit over there in the gallery while he's and listen so that he can opine. But I think that interview indicated on top of it that my finding that he's not qualified to know what a producer does. So he can testify about the SAG guidelines, but he cannot opine on what Mr. Baldwin did as a producer.
So he is allowed to testify, but not about producer stuff.
Was good or bad. All right. I'm going to revisit the producer. I'm going to make the following finding. I'm having real difficulty with the state's position that they want to show that as a producer, he didn't follow guidelines, and therefore, as an actor, Mr. Baldwin did all these things wrong, resulting in the death of Helena Hutchins, because as a producer, he allowed this all to happen. I think that when you look at the relevancy, I think that one of the reasons why I think I'm having a hard time wrapping my hand around it, to be able to say, Mr. Baldwin, because he was a producer and he was the boss, although there were more than one producer, and he couldn't do anything without, looking at those contracts, he couldn't do a thing without running it by, including hiring somebody, without running it by whatever that entity is in the contract. But I do not believe that it has any tendency to make more probable than it would be without the fact that Mr. Baldwin individually as an actor committed involuntary manslaughter through negligent use of a deadly weapon and the alternative theory. The probative value is not substantially outweighed by unfair prejudice and certainly confusion of issues to the jury. So I'm denying evidence of his status as a producer.
So the judge will not allow them to argue that he was a producer, he knew and controlled all safety on set. That is a huge, huge win for the defense. Absolutely huge. Okay. That is something that most of the chat thinks should come in. Most of the chat thinks is damning for Alec Baldwin. And most of the chat thinks proves that all of the issues in this case, he could have somewhat handled. I don't necessarily disagree with, he could have changed a lot of this. He could have made it a safer place, but they charged him with negligent use of a firearm, right? And he did that as an actor, not a producer. So I do agree with this judge's ruling here. And I thought she did a really good job of laying down all of her reasons why. Kim R asked, I'm a little late, but since she denied the motion to use the producer theory, how come the motion to use the defense witness related to the theory was approved? Shouldn't both be denied? So that was interesting, but the expert the defense had in response to the producer theory was first, she's going to allow them to be on the witness list and potentially be called. But if the producer theory never comes out and that's all he's going to do is rebut the producer theory, he's not going to be allowed to be called. Bev, watching via generator powered phone, Hurricane Barrel. Oh, cow. Can you talk about why they're focusing between Baldwin's role as an actor versus producer in terms of his culpability? Pointing and firing a loaded gun seems negligent regardless. Yes, but it's negligent as the actor, not the producer. So like the safety bulletins and all that stuff, they're not going to allow that to be attributed to Baldwin. A lot of the stuff that was attributed to Hannah Gutierrez-Reed and the armor being the last line of defense and all that stuff, well, they could have made similar arguments about him as a producer. They're not going to be able to do so. Troublemaker Baker says, but isn't it presumptuous to tell a judge how to run a courtroom? Actually not. So a couple things. Number one, it's not presumptuous at all. If you've seen a judge let a lawyer run rampant around the courtroom, breaking all the rules, it's not presumptuous to say, Judge, we really can't be having that. That's against the rules. And number two, judges take lawyer suggestions all the time about how long a trial is going to be, how it should run. It's not presumptuous at all. But at the end of the day, the judge makes the call and you have to live with it as a lawyer. Yobi, haven't seen Alive in a while. I'll be at the Hard Rock in Miami for Copa America finals. That's cool. And I am definitely not stopping by your office. It'd be a pretty long drive. But I'll tell you what, every day I feel like I show up to my office, I've got another box from the Yobi family with some golf trinket in it that is really cool. One of them, if you check behind my head, is right there. That's my favorite one so far. And the coolest one is that box of like custom balls and tees for congratulations on 400,000 subscribers. So thank you. Wait, they can't even say a word objection without approaching the bench. Surely I heard that incorrectly. Seems as so, but hopefully she does relax it when we see all of this happen, hopefully properly. Lane, producers are often in name only. There are different kinds of producers. Sometimes it's in their contract and they may have also helped fund a film, but he wouldn't be the boss. I think the reason they wanted to argue that is that's what a lot of people said, is that it was kind of like he was the boss. You weren't going to buck him. We were going to do whatever he said. What percentage of your paid subscribers are for people? I don't know what the membership breakdown is personally. Excuse me. Reese's mom. If they want to include his producer status, they should charge the other producers. Hey, that's a good point too. It's a good point too. He can't be the only producer they charge, right? I like that point. All right. Okay, they get back to arguing prosecutorial misconduct here in a couple minutes. So let's get to that.
Trial. Numerous allegations that the state has engaged in misconduct and trying to deprive the defendant of his right to a fair trial, and those have no place before the jury, and we'd ask that the court preclude that.
Let me just be clear about what we intend to do and what we don't intend to do. This is not going to be a trial about the ethics of the prosecutors. It's not going to be a trial about they should have dismissed the case a long time ago. They did. They took it back. Well, none of that's coming into this trial. No intention. What we intend to do is exactly what...
So every time they would kind of get accused of doing something underhanded or like, oh, there's a slimy defense attorney, they got up and they're like, we're not going to do that. We're not going to tell him how we used to be prosecutors. He does actually, one of the lawyers mentions it in this pretrial. He goes, I'm not going to say it in front of the jury. But he's like, yeah, we're not going to do that. We believe it. We believe they shouldn't have charged it and they should have dropped the charges, but we're not going to argue that in front of a jury. We know you can't do that. I like it. I like that style a lot. Not going to do anything underhanded.
I discussed we were going to do with Schilling, for example. We're allowed to demonstrate that bias, improper motive, incompetence of the government investigation. We're allowed to attack the credibility of witnesses as it relates to the government investigation. For example, Your Honor already ruled that with respect to that meeting between Mr. Ziegler and Mr. Haig, that gets to be disclosed to the jury. In fact, the prosecutors are required to disclose it to the jury, you ruled. And so all of that goes back to the black letter law that we started with on that prior motion in limine. We're allowed to demonstrate the bias, the incompetence, the improper motivations.
He always says that's black letter law. That's like, what he means by that is, Judge, that's 101. Nobody disputes that. Nobody argues with that. That's got to be how it is.
We're allowed to attack credibility. We're allowed to attack the fact that the FBI destroyed this gun, et cetera, et cetera, et cetera. All of those issues are fair game Hornbook law. We intend to introduce that. The state shouldn't be allowed to preclude it. I have nothing further, Your Honor. It's black letter law.
Thank you. Any reply?
Black letter law.
Just briefly, Your Honor, I think we may be in agreement. What the reason for this motion
He's
was
like, we can
essentially
pick it apart, say bad investigation, but we're not going to say the things he said at the beginning, which I think is totally proper. And how he said it, I don't think anybody has an argument with. It's black letter law.
to preclude the defense from essentially making personal attacks and allegations of prosecutorial misconduct. We agree, and we will present evidence about the Ziegler-Haig virtual meeting about the gun. So, but we just asked, given the contentious nature of this case so far, that we focus on the evidence and not on allegations, personal allegations and attacks during this trial.
All right, thank you. The court rules and reasons. The court agrees that the prosecutor's misconduct as alleged by the defendant in his pretrial motions may not be brought out at trial. The misconduct is not relevant evidence, and even if it were, its probative value is substantially outweighed by the danger of unfair prejudice and confusing the issues. However, to the extent that the defense may elicit evidence about the Santa Fe County's investigation, the FBI testing, the Haig's 3 reports, and his meeting with Ziegler, this evidence is relevant as it makes a fact more or less probable, and the fact is of consequence in the action, and weighing it, the probative value of the evidence is substantially outweighed by danger of unfair prejudice, etc. All right. Thank you. Now we're
All right. Then they talk a little bit about more experts. The judge will rule on some of them as they go. They talk about the OSHA report, which was a big part of Hannah Gutierrez's case. And the judge said, no, we're not going to talk about that, which was interesting, right? Because OSHA had all sorts of things to say that Hannah Gutierrez's team won or liked, I should say. And the judge said, if you get into that defense, then I'm going to allow the producer theory because you're opening the door to the producer theory. So I bet they're not going to do that. Then another big question that came up was the autopsy. And the intubation, and were there problems with that? And are they going to try to blame the death on that? And they had an argument here. The judge made a decision on.
Homicide cases. No, and often there is I wasn't, I don't say these things. We're not saying that some other causal factor killed her. So this makes a balancing test very, very easy. That doesn't happen in every homicide case, right? And also, I wasn't,
Sorry, the beginning of the argument is, we don't need to show all these autopsy photos. We don't need to talk about the death. We're going to stipulate to that. It just makes it worse. It garners sympathy, and it, inflames the passions of the jury. And this is kind of his argument against putting those pictures in. And this is where he mentions he was a prosecutor.
I don't say these things in front of juries, but I actually prosecuted homicide cases. No, and often there is a discussion over, they don't always come in. And often there is this thing where sometimes prosecutors want to put them in to gin up the jury, and judges make calls all the time that it's just not necessary.
Gin up the jury.
We don't need to remember her that way. We don't need to do that in this case. I don't need to do that in this case. And this court can very well, like the court said to me when this hearing opened, take order of the court. It has the discretion to say, no, pictures of this tragic dead body is not necessary here. I'm telling the court again, I'll say it now, I think a second time, which is we are not making an issue out of the cause of death, period. If they want to take these people off the witness list, they can. But if that's what we're doing, and I've withdrawn our seeking the medical records, then I've left the court with a very simple, in my judgment, balancing test. And I'd ask the court to really think about.
We just got an indication of some strategy there. They removed their request for the medical records. They're withdrawing their argument that there's some other cause of death, and they're balancing. They're like, we could argue it was intubation or something else, and maybe it wasn't the gun that caused the death, so she shouldn't have been dead. She was just hurt, and it should change the charges and things like that. And they balance that versus maybe if we just get rid of all this, the judge won't put the autopsy photos. They won't garner sympathy. The jury won't get angry and, feel like they've got to find somebody guilty or there's no justice. So it's a balancing act that attorneys do, especially trying cases. There's a lot of strategy in it. What arguments are you going to make? What arguments are you not? What are you going to try to push? What are you not? Pick your best arguments. Don't throw it all up against the wall. And we just got a little window into how they were looking at this strategy. So how do they object? Just jump up and approach. Basically, they say, objection, judge, can we approach or something like that? Or just, can we approach? And the judge will know what they mean. Azam, could there be any lawsuits for him being a producer? Absolutely, there can and were and probably are. And additionally, the vicarious liability discussion is a civil discussion, and he was on the hook for a lot of that. Payments were made, settlements happened. So yes, that was a big part.
When this verdict comes down, having faith that this was a fair trial and the verdict was based on the right reasons, you can't have, it's hours of testimony, hours in the Hannah Gutierrez trial about it. And it's different here because the gun was in his hand. The gun was in his hand. So to allow hours and hours of testimony when we have, the state has 5 days to present this case and we need the opportunity.
That's also a good argument, a good point. It's like, that's a lot of testimony. Are we really going to let them do that? And this is also him setting up a future argument. If they take too long, after they take 2 days to go through stuff that he's arguing is irrelevant because we've already stipulated to it, judge, you better not give them extra days. They said they need 5 days. If they want to take a day on this, then so be it. But don't give them extra time for stuff like this that's really irrelevant. That's a good setup for later.
opportunity to rigorously cross-examine. It doesn't make any sense. I don't think it's fair, and I don't think the court should allow it. Thank you.
All right, the court makes the following ruling. All right, with respect to the character of deceased of the deceased, certainly if Mr. Baldwin was going to get up, you'd want to go, how did you come about getting this this job, so to speak? And I think it's just an introductory way to tell the story. Now, I do remember Mr. Souza going into, we met, I
And this
liked
is
her.
especially with Joel Souza on the stand. And it was pretty gripping testimony. If you remember back last time, it was really sad. It was really touching. And it seems like the judge is going to limit it just a little bit, but she's going to allow it in overall and denies the defense's objection here to this stuff.
We had things in common, you know, et cetera, et cetera. I think all that needs to be said is that she was one of some choices. He felt that she was a good fit and that she was the director of photography. That's it. Okay. Now, with respect to the moment of death and subsequent pain, I think that does go to the death. That's one of the elements, and the death and the injury, and well, the death. And where am I? And I do think that that makes a fact more probative, and that is the death. And that I don't think that is its probative value substantially outweighed by unfair prejudice. Having said that, I'm trying to recall everything that occurred regarding that, and I do think that the video is appropriate. Now, I think there were some people that got up, and this may be what both of you have referred to, where they talked about being upset. They talked about, how upsetting it was and things like that. We don't need that. We just need the lapels videos as to what happened with respect to her being shot and Mr. Souza being shot as well. So that's the lapel camera depicting the crime scene. Am I misunderstanding anything else on that?
From the defense's perspective, a lot of this also goes to 403 and cumulative lists, right? So
could you just answer my question? Okay.
yeah, well, I think
I don't want you to argue again. You already had your chance.
I think the answer is yes, Your Honor. I'm not. If I understood the court's ruling, I think the answer is that yes. If the lapel videos are the way that they're going to show where the bodies were, or the man.
When Lieutenant Benavides is in there and he says, "Everybody clear out." Is that the video?
And primarily also Officer LaFleur, who's the first officer on scene. That video.
There was an autopsy photo that was pretty much agreed it was prejudicial, or maybe it was somewhere else where her shirt, I think. Which part of the autopsy photos? I don't know. But the autopsy photos in my mind are the body.
So just to iron it out right now, we've got pretty much the same photos of the body that we showed during Gutierrez, nothing overly dramatic. And there is a photo of the bloody clothing, and part of the reason that's relevant is because her cause of death was exsanguination, so she bled to death. So the photos of that amount of blood go directly to her cause of death.
I will allow that. All right. You can revisit that, defense, but I do anticipate you may bring up some information about the tubing.
Just to say that there, and I know the court has one more argument, but the court.
So the intubation, again, which a lot of people thought was going to be part of this case, and even the judge thought it was going to be part of this case, the judge or the defense kind of throws that out at this point.
Looking at me for guidance on this, that we're not going to do that. We're not maybe going to do that. We're not going to do that. So when we say that we're not,
he's like, let me just take that off the table. It's not even a maybe. We are not going to make that argument. We are agreeing with the cause of death. And I don't know if the judge doesn't believe him or the prosecutor doesn't believe him or what, but I think I would limit this even more. This is not a fact they have to prove. It's a stipulated fact. And the judge needs to be careful about how much she really lets in to garner sympathy or inflame the jury when they see these horribly sad pictures and hear, about the death that they're all agreeing this caused the death. The question is, what did Alec Baldwin do specifically?
Do that. The court can count on that. And that makes those.
Well, you didn't say that. That's not.
Oh, I thought that's what I was going to address.
You could ask the doctor. You said you didn't care about the UNM records, but that you didn't say you weren't going to ask the doctor.
If I wasn't clear, I'll make it more clear, which is we are not going to ask the doctor about that. So if we're not going to ask.
He's like, Judge, we're not even going to ask the doctors about that. And Melly, I only agree to a certain extent. First off, the jury's not in the room. So let's remember that, number one. Number two, there's a lot we can do on our phones these days. We can look up things. We can talk to lawyers. He might have more lawyers than are sitting at the table, or a paralegal back at the law firm. And he's like, didn't I say this? Or do we have this document? Or look for that. There's a lot of things that can be going on the phone that are not necessarily disrespectful. And if the judge isn't telling him to stop, I'm going to have to assume that it's okay to use at this point. Again, let's remember it's not in front of the jury. But I get it. And in some courtrooms, you're not allowed to use your phone at all.
We're not going to seek to introduce medical records, and we're not asking the doctor about that. There isn't a basis of relevancy anymore. There just isn't. And so I'm asking the court that they now have several ways the court has just allowed for them to present that this was a death, which we concede. So, right?
All right, that's fine, but they still get to do it. I'm saying no to you.
Right.
All right, so let's not do the shirt.
She's like, I get what you're saying. I'm just saying no. Do you understand that? Yeah. Soban, I agree. I think this judge seems completely neutral.
Well, no, I'm going to allow the shirt. You said that she bled to death. There's nothing wrong with that. All right.
And I'm gonna start calling off witnesses then to testify that she was correctly intubated. Are we clear that the defense is not gonna raise that issue?
We are not raising that issue as to the cause of death, and we maintain our objections to the exhibits, and we understand the court's
So
ruling.
again, and the reason the state is correctly confirming this on the record is if we release these witnesses and they're no longer available because they go on vacation or whatever because we release them, you can't change your mind and then say mistrial and all this stuff. And the defense is like, I'm being as clear as possible. And I don't think they're going to change their mind. This will be a very bad look and would just create a mistrial at their fault, the defense's fault, if they change their mind on this. They are not leaving any gray area. They're saying it's not happening. So the state does not have to worry about disproving the intubation theory causing her death, which is interesting based on what a lot of people were saying during Hannah Gutierrez-Reed as a possibility. And I was like, I just don't know. I don't know. I need to hear some expert testimony more about that.
So just to be clear, the video, and all I'm remembering is the video. Okay. So if there's something else that comes in about in the church, then we need to revisit this because I am making a ruling about the video. I don't remember if there were any photos. I don't think there were photos, but I remember the video. Okay. They get to put on what the church looked like. Secondly, and also that gives an understanding of where Mr. Souza was for various reasons. Then with respect to.
All right. That's basically the gist of what we wanted to get there. Court will allow exhibits and opening statements for both sides. Okay, so then there was some discussion about whether Helena Hutchins actually told Alec Baldwin where to point the weapon and statements that she made. And the state wanted them to only be allowed in by Alec Baldwin for the effect on the hearer as an exception to hearsay. The defense wants them in by anybody that could have heard them or anybody that, maybe even Alec Baldwin told them to. And we're just going to listen to about a minute of the judge's ruling here.
The following ruling. First of all, assertions can be, or directives can be assertions. So I certainly researched that. But what I'm ruling is that the statements are not being offered for the truth of the matter asserted. That the statements were said in defendant's presence and had effect upon the listener demonstrated by his actions. I have done a lot of research on the case law to make this ruling as to whether the defendant has to testify to be able to get that exception in. And I have read many cases where another person testified that the defendant was there and that he heard these words. So I'm going to let it in on that exception. And then that will obviously be an issue for the jury. Thank you.
She's saying if they were there, they heard it, or they know that the defendant heard it and his effect on the listener, that it's not hearsay, it's an exception, and it will be allowed in. So the defense won that one, which is interesting because I don't think we heard any of that in Hannah Gutierrez-Reed trial, which KO said, same judge as Hannah Gutierrez-Reed, don't we know all shall rule? So no, there's actually an interestingly, a surprising amount of different issues and different decisions that she's making in this case. We heard a lot about OSHA and Hannah Gutierrez-Reed. That's not coming into this trial. So I think there's going to be more differences than you expect. A lot of similarities, especially setting up the scene and hitting the investigation. Different because it's different defense lawyers, but similar themes there. But I think we're going to have a lot of differences in these two trials. Olga said, might be a dumb question, but will the jury know about Hannah Gutierrez-Reed being found guilty, or will they exclude this detail from jury selection? Usually they don't know unless there's some kind of stipulation of the parties or reason that they should know. If she is called to testify and she's in her orange jumpsuit, they might find out. So there are ways that they can. Usually not, though. Usually not. All right. The next portion we're going to listen to is the defense wants to be able to put up and tell the jury about some arguments that the state made in Hannah Gutierrez's case that might be different in this case, and basically make them look like they're flip-flopping and trying to have it both ways.
Yes.
As your Honor knows, we cited multiple cases in our briefs saying that the government, the party opponent, are allowed to introduce statements that they've made if they're inconsistent. It's black letter law in a number of cases. In fact, the state's brief acknowledges that it's black letter law. Your Honor mentioned the Montoya decision. I've read that, and this is consistent with our position. Your Honor, in that case, the prosecutor said an opening statement to the jury, you are going to hear a witness testify that that witness heard another person say X. The second trial, the defendant said, I want to introduce the prosecutor's statement in the opening as an inconsistent statement in this trial. And the court said, well, you're not allowed to do that because it's not an inconsistent statement. It's the prosecutor saying what the jury should expect to hear from someone say about what someone else said, double hearsay. And the court said, and this is really important, the prosecutor's opening statement to the jury was not an obvious admission of fact that might have constituted an admission of a party opponent. In other words, if it were, we'd admit it because that's black letter law, but it's not. It's a prosecutor giving a sort of preview, not making an assertion factually, and therefore it's not a party opponent admission. It doesn't come in. Here, the statements that we are intending to use are not comments on what the jury might hear from a witness who talks about another witness's statements. These are statements that are clear, direct. Ms. Gutierrez-Reed's training of Mr. Baldwin would not have made a difference. Now they want to come in potentially in this trial and say, if Mr. Baldwin just did the gun training, it would have made a big difference. That is a direct inconsistency. It's not a comment about what a witness might testify about another witness's statement. The same thing is true about Ms. Morrissey's statement that Hannah Gutierrez-Reed is the autonomous decision maker, and so forth and so on. We've listed a number of these statements in the brief. These are direct factual assertions by the state in the prior case. The black letter law is that that's a party admission, party opponent admission, and therefore it comes in. The Montoya case is consistent with that, and therefore I believe it supports our position that we should be able to introduce this at this trial. And that's, again, consistent with what the
He's
state...
arguing the state's a party opponent. If they made statements before and we want to use them against them now, we should be able to. It's hard to do that when lawyers are making arguments. It's not evidence. That's said in every case, in every trial. It's not like this is something in a document or an email. It's something that was argued at trial. It's kind of a gray area. We'll see where the judge comes down.
Told Your Honor to rely upon it in Justice Thomas's concurrence. If the prosecutor wants to make those statements, that's fine, but there's a risk of undermining the prosecution's case because the second defendant has every right to present them to the fact finder as contradictions. That's from their own case. And that's exactly what we're asking the court to allow us to do here. Thank you, Your Honor. And unless you have questions about the Montoya case, thank you.
Is this a defense or a state?
The defense.
I believe so.
Okay.
So you have two different trials of two different defendants. So the prosecution can say X in trial of defendant one with the facts that are available and still present a different argument with the same set of facts, but as to defendant number two. And so the statements made by Ms. Morrissey during her arguments to the jury in Gutierrez applied to her culpability. That doesn't mean that the state should be bound or that the defense gets to introduce her statements to the jury in Gutierrez because they pertain to.
So it's annoying, and I disagree with like the way that she's arguing with it, but overall, I can understand why judges would not allow you to enter certain things lawyers say in certain cases, but it's annoying that they can say, it's all this person's fault. She did everything wrong. It's all on her. And then, no, it's all his fault. He did everything wrong. It's all on him.
To Gutierrez. This is a different defendant. And so the facts are.
Their theories should be consistent. She allowed the firearm to be, or the live round to be in the firearm. He pulled the trigger and pointed at her. Both of those things are wrong. Both those things are negligent. Both those things caused Helena Hutchins' death. I don't understand why they would have inconsistent arguments.
Slightly, they're still the same well of facts, but the facts that we're drawing upon for this defendant are slightly different than the facts on Gutierrez. And more importantly, even if the court were to find that, well, okay, statements by a prosecutor are admissions by a party opponent, the court still has to subject that decision to a Rule 403 analysis. And under Rule 403, allowing the defense to introduce the statements Ms. Morrissey made out of context, so they're picking and choosing specific statements they want to introduce, would create confusion to the jury. It would be misleading to the jury. So the statement that counsel indicated that Ms. Morrissey made about Ms. Gutierrez being the autonomous individual, that pertained to Ms. Morrissey's argument as it related to ammunition. With regard to another statement that Ms. Gutierrez was not rushed, but yet in this trial, one of the issues is the defendant rushed Ms. Gutierrez. She was not rushed that particular day on October 21st, but rushed on other days to reload the firearm. So these would be completely taken out of context, Your Honor, and the court has the discretion to not allow these statements to be introduced as admissions by a party opponent. And I think that Montoya does apply because these are arguments by counsel that the court should exclude at a minimum under Rule 403. Thank you.
Just one case, and then there's a defendant in a second case. That's the only situation in which the party opponent admission rule comes up. Every single time a defendant in the second case says, I want to have the fact finder consider the contradictions that were said in the first trial, and the court said, yes, you're allowed to do that. That's a party admission. Every single one of those cases involved two different defendants. And so trying to distinguish this case by saying, well, that's Hannah Gutierrez and this is Mr. Baldwin, there's not a single case where a party admission was allowed in this context where that wasn't the case, two different defendants. That's what the case law stands for. The element of confusion that the state is relying upon, they're saying, well, you have to balance 403. Every single case, black letter law, party opponent admission comes in, as long as it's not hearsay upon hearsay upon hearsay, where a prosecutor saying, this is what you expect, that's not an admission, it's admissible. And so these 403 balancing was in play every single one of these black letter law cases where the court said it gets admitted. And as Your Honor knows, 403 is an extraordinary remedy. So to apply 403 balancing and say it'd be too prejudicial when the black letter law says, as a matter of law, it's not because you're allowed to introduce it, there's no case to support that, Your Honor. The statement should be allowed.
Thank you. The court denies the defendant's motion. This is an issue that the court has discretion on. I'm not mandated to put it in. I have the discretion on whether to put it in. First of all, I don't.
Again, and that's why the gray areas are a lot about to do with judicial discretion. I would probably allow them to make certain comments if it's really contradictory to what they're arguing in this case as the state. But if it's kind of like sounds similar, maybe just said a little differently, that's really confusing to the jury. And you shouldn't be impeaching prosecutors for making like a slightly different argument. But if it's completely different, or they were blaming Hannah, now they're blaming Baldwin for a certain act, I think it should be allowed in. The judge is not going to allow any of it in.
I think that what the prosecutor said in Hannah Gutierrez's case is relevant to a relevant fact.
So again, Reese's mom, black letter law or Hornbook law is like well-established. Everybody knows it. This is how it always happens. Hornbook is like a treatise where somebody explains what the law means. It's like everybody agrees on this. This is simple stuff. This shouldn't even be a gray area. It's like, trying to say this isn't even something that is arguable. Yes, it seems like Morrissey is still the lead prosecutor.
And even if it is a relevant fact, it's probative value is substantially outweighed by unfair prejudice and confusion to the jury. In addition, I don't think the theories are inconsistent. But a continuum. Hannah Gutierrez loaded the weapon with live ammunition. Defendant Baldwin took that weapon with live ammunition and, according to the state, fell into follow firearm safety as an actor on the set of Russ, which continued into October 21, committed involuntary manslaughter as well. So I don't see it as inconsistent theories or inconsistent fact assertions, maybe separately hanging out there in one sentence, but I'm denying the motion.
All right, so that was denied. Then we get into a huge motion to compel. All these things the defense says the state didn't turn over. It does seem like they maybe violated their duty to supplement within a relevant time period. They gave some things that were completely redacted. And the defense is like, we got to throw this stuff out. We got to dismiss these charges. Here are our remedies, judge, that we want. And the judge is like, well, Mr. Defense or Miss Defense team, you forgot one remedy. One remedy that I could easily say is the remedy we want to do in this case because you don't want that remedy. And I thought it was very interesting to throw this out there.
One is to dismiss the case. The second is to
know and actually draw their own inference that this information would have been helpful to the defense had they been able to see it.
So those are four solutions. One is to dismiss the case. The second is to eliminate subject matter. The third one is that, which is ongoing, is for them to keep going, keep looking. And then the last one is
the inference instruction.
Well, what you're asking for is a continuance. So why don't you come out and say it? Because
she's like, well, that's weird. Why didn't you just ask for a continuance? Give them more time to answer these motions to compel and give you these documents. You want them to find them, right?
The inference instruction.
Well, what you're asking for is a continuance. So why don't you come out and say it? Because you don't want one. How are they going to keep looking for things without a continuance?
What we're asking, Your Honor, for right now is those specific documents that are provided to the court.
Four things, okay? And I'm asking you, how is that not going to help if I don't give you a continuance? You are essentially asking for a continuance because you're saying they have to keep looking. We have 8 days of trial and they have to keep doing this. What does that mean? How does that compute?
So, Your Honor, what we're asking for is not actually continuance, and we're not even asking for those extended things. What we're asking for is we've identified a discrete number of documents now.
You've got to adjust your request then.
Okay, Your Honor, so let me try to do that then. So what we've handed to the court is a number of documents that still remain redacted. We cannot see the contents, is what we provided to the court. We're asking that the court lift those redactions, or order that the state lift those redactions, so that we can see what those are, because those are clearly discoverable, and yet we still don't have the contents. That's one request that we're making. The other request is related to exclusion of subject matter, and that's because we don't want a continuance. We don't want a
What is the
continuance.
subject matter you want?
The subject matter, Your Honor, that we're asking the court to not permit are those subjects that are included in those exhibits that I just detailed for the court. And so that would be.
This is the defense, by the way. This is a defense attorney. So basically what they end up doing is the judge is ticked. And she's like, you know what? Get out of here. Go talk for an hour. See if you can figure this stuff out, or I'm going to continue the case, which everybody knows the defense doesn't want. Prosecutors don't seem to want it either. And she's like, get out of here and go figure this out. So the main prosecutor with the short blonde hair, Morrissey, is still there, but the male prosecutor is no longer there. And there's a different female prosecutor that's been arguing a lot of these motions that's in. If he's acquitted as an actor, can he be retried as a producer? No, probably not. It's the same set of facts and circumstances. So I think the answer is no, personally. What do you think of the judge's demeanor thus far? Lawyer, it doesn't bother me at all. I know some people are going to say she's a little bit mean or rude or whatever. She makes decisions. She's decisive, and she puts her reasoning on the record, and she moves on. That's really all I ask for. That's what I like out of a judge. I want somebody who's decisive and sticks to their decisions. Now, obviously, I like a judge that I agree with all their decisions. That almost never exists. But here we are. All right. Then after they go and talk, they come back and they've kind of resolved some of their issues. And we're going to listen to this last clip here about, the judge very smartly is like, well, okay, city slicker, big shot defense attorneys, if you're saying you figured this all out and you don't want a continuance, are you abandoning these arguments? Because don't bring this up on me later. She's very smart and setting the record straight and making sure it's all done right.
We were able to meet and confer about Voire, and the state can correct me if I'm wrong, but one issue that you Voired about in the last case that we think.
And then they're going to talk a little bit about jury selection. We can talk about for a few minutes. I've only got about maybe 5 minutes left.
At least I will.
Let me just go
Sure.
back up for a minute. So for the record, Ms. LeBlanc asked for 4 remedies. And I'm understanding that you have abandoned that request and you're satisfied with the compromise of witness
You're
order.
abandoning your big request on motion to compel and discovery violations that you wanted this case to get dismissed over. You're abandoning that, right? Because if I got a rule on it, I'm just going to continue the trial. That's what it seems like she's threatening them with.
And that the state will take a sample of IPRA issues in camera.
Yeah, we're holding. Obviously, time will tell about the.
Well, that's
the-
not going to work for the court.
We expect that to resolve the issue. Obviously, we can always bring an issue back. As I said before, we don't intend to bring this back to the court. So I would say that it is mooted or held in abeyance for now. Obviously, they just gave us a Giglio disclosure, which was also helpful.
Well, what I'm trying to avoid
Yes.
is that this continues through the trial. And that's why I think a continuance would be the answer if it continues through the trial. And I want to do it now, obviously, if this is going to continue. So you all have to have resolved it.
Yes, it's my impression, based on the representations from the state, that they don't have any further disclosures, that they're willing to do this in camera in good faith, and that they're going to give us more advanced witness order notice than they would have necessarily been required to do. We believe that has resolved this issue.
I would
So
like
again, before they were like, we don't even know who they're calling or when, creates issues for us. It seems like in this meet and confer, they solved all those issues.
order.
But he's even
Regarding-
like, halfway in, halfway out in good faith. We're going to believe that they're going to do X, Y, and Z.
The motion.
Yes, Your Honor.
And I would like you to prepare it.
Yes, Your
Okay.
Honor. So can I just turn to that final quick issue?
But if
Yes.
it's going to say being held in
Right,
abeyance,
let's handle that first, and then we're going to talk about the jury selection issues.
I'm not going to sign it.
Yeah,
And I would like that tomorrow
yes, Your Honor. I won't use
before
the
the
word.
jury's sworn.
Understood, Your Honor.
All right.
The final issue that Your Honor raised before our original break today was the voir dire and how to run it, and
Yes.
any
Yes.
insight we had. The parties were able to confer on that too. In the Hannah Gutierrez Reed case, you did the voir dire regarding guns.
I do?
I think so. I think you made that one of your questions to the panel. I could be wrong. I
I don't think so. I usually would not do that.
You would have. Okay.
Yeah.
So that's just one topic that I think may be of the sensitivity and the type of topic that we may want the whole panel to hear and be able to approach on as a topic potentially.
I usually do not conduct any particular question other than what the UJI requires the judge to
Understood.
go through. And it usually stops on is there any reason why you can't serve on this case? And then I turn it over to you for the specifics. So
Fair-
I don't, so,
Fair enough.
so what do you say?
Now I'm saying,
And this is stuff they're talking about right now that's happening today because they're picking this jury today. I think they expect to have the jury by the end of the day today or tomorrow because she told them, or that one of the prosecutors asked, are you expecting opening statements tomorrow? So they expect this to move pretty quickly, which is kind of crazy with somebody as big as Alec Baldwin, and the fact that we've already had Hannah Gutierrez-Reed's trial that a lot of people watched, and the fact this was around a movie set in Russ and all the reporting that it would only take one day to pick the jury, but who knows?
very little because you've just explained to me exactly how my understanding had been that you addressed a couple of these issues
Of
yourself.
course, I
So,
could have, can't remember too much. Okay.
and then the only other topic that we're going to raise is just the strong views on Mr. Baldwin in both directions that we're going to ask. We're going to be more eager to ask the court to take people individually on. But other than that, what the court has
He's like, we're going to have to ask if they have strongly held views or beliefs on Mr. Alec Baldwin himself, because that could be an issue.
said made sense, and we have nothing further.
Well, so are you going to ask to speak in private? I'm not sure on what you plan to do on that.
Well, I think that if people have very strong views, if somebody indicates very strong views on Mr. Baldwin, that is the type of topic that I think has the potential to taint the jury pool as a whole.
Oh, so you mean come up to the bench?
Sure.
Okay, you mean come up to the bench
Yes.
versus what, are you going to speak in private? Because sometimes they don't stick around to speak in private. So you want it up at the bench. I just want to get the visual on this.
Yeah,
But what the judge is saying has actually happened in cases where somebody will raise their hand and we write them down. We're like, okay, we'll talk to them later. And then we never talk to them later, or they don't come up, or we say, okay, stay after and we're going to talk to you. Like everybody who has a problem with Alec Baldwin, raise your hand. So, 6 people raise their hand. Okay. You don't talk to him right there because you don't want to poison the whole jury pool. If they say, I hate him because this is his political view, somebody might not know that about him. Or I hate him because he was in this movie. Somebody else might not know that about him. Or this is his family member or whatever. You don't want the whole jury to be poisoned by one person that doesn't like something about Alec Baldwin and won't give him a fair trial, or that loves him, too much on the other side. But you want to make sure you actually talk to them and dig into it privately. So how are they going to handle that? What is the process going to be like? And anything that's individual voir dire, individual discussion with the jury, is going to take longer. And it seems like they did a lot of that in the first trial, and she doesn't want to do as much of that in the second trial, which is crazy. This trial, to me, is way more publicity than Hannah Gutierrez-Reed trial.
I think that's what we had envisioned, that just, or frankly, if somebody has a very strong opinion on one of those two sort of, threshold issues, that if they raise their hand, it indicated, thank you, juror number 14, for indicating you have a significant concern on this topic. We're going to come back to that juror then in a break, basically, is how I pictured it happening. And if the state pictured something different when we were discussing it, or if the court doesn't want to do it that way.
No, but just so you know, how I've experienced this, when people want to share their views very strongly, they will keep raising their hand. They will meander back to what they really want to let you know, even if the question is.
So this is the other thing. It's like the judge is like, whether or not people talk about, what the question is, they always get to what they want to talk about. And I can attest to that. I actually saw the guy at the gym that was the one that nuked my last jury, literally, because it's like same community. This is where everything happens. Maybe I'll go up and talk to him one day and be like, hey, remember the trial you were on that, the whole jury got nuked basically because of some of your comments? Be interesting to talk through it with him. But yeah, so one juror can really get to their views and create an issue for the whole jury panel. So you don't want that. And also some of the juries that are a little out there with some of their opinions or thoughts or views, they make sure the whole room knows and hears what they want to talk about. And it can really affect the panel, the trial, the case, the lawyers. So you got to be really careful about how you handle that. You don't want to piss them off. You don't want to be a jerk. Just generally, you don't want to be a jerk, right? But you especially don't want to be a jerk in front of a whole panel of people that you're going to be talking to, trying to prove your case, that your client's life is in their hands, right? So it's hard to deal with people like that. All the lawyers and the judge usually work together on how to deal with it. And that's kind of what they're discussing now, which is always interesting and important in cases like this. Linda, question, Peter, why wouldn't they want a continuance here? Why the change of wanting all the info they asked for? My guess, it's a pure guess, is that it's not that important of information. And number two, they're very confident and feel like they're ready to go and they want to get this case tried. And Alec Baldwin does not want this hanging over his head any longer.
Is not germane to that. And so if we say, do you want to speak in private? Sometimes they do not come back and speak in private. So you don't, you'll have to decide what to do with that. They come back for the selection, but they don't come back to speak in private. They don't stick around for speaking in private. So I don't know how you want to do that. I just don't want you to think here that.
And he comes up with a really good solution. And Shoban, you're right. Usually it's the other way around, but not here.
People.
Yeah, obviously they leave, they're not a jury. And
No, they just.
Also, P.S., sometimes with these kind of attorneys, they're very ready and they already blocked these 2 weeks. They don't want to block another 2 weeks. Be very hard for them to find 2 more weeks and expensive.
Don't speak in private, but then they come back. They don't leave like goodbye and not come back. So we'll take a recess and then we'll say, everybody that wants to speak in private, stay over there and we'll call you one at a time. And they just don't.
So now I realize why we're talking past each other. But so the way I've done it, especially in cases that have been heavily followed and there's media involved, is the court clerk or somebody will take, or I can take a roll call, and it'll be 14, 18, 19, 20. They go into the hallway and they say, jurors number 14, 18, 19, 20, please line up at the door during the recess.
And that's how you make sure you don't miss anybody. The bailiff goes out, reads their numbers, calls them back in, so they're forced to come back in so you don't miss out.
We speak to them each for 60 seconds during the recess, and then we're done.
Okay. Well, I hope that they do that for you.
Okay. We have nothing further. Thank you so much for the court's time today.
Okay.
And that's it. So really interesting day. Some wins for the defense, some wins for the prosecution. A well-fought battle is what I expect. Also, I didn't announce this off the top. We are redirecting into a about 20-minute Karen Reed update on Proctor and the judge's impoundment of the jury names. I've got some thoughts on that. It's a shorter one than normal. Didn't have time to do it live yesterday, so we're tacking it on here. You're going to automatically be directed. Make sure you have the autoplay turned on. But before you get to that video, make sure you hit the like here. Make sure you subscribe and hit the reminder bell so you don't miss the future Baldwin videos. And when you get to the next video, if you wouldn't mind hitting the like again. I appreciate you guys so much. Appreciate all the questions and comments. We're going to be following this one. You guys picked the content here, right? And this is a case you guys picked. Welcome to Pebbles and all the new members that joined today. I appreciate you so much. Till the next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.